So if you are a homeowner about to sign an agreement to remodel your home with a general contractor, or you are a general contractor that is about to make that big sale and sign that agreement to start work, this episode is for you. I'm here with Aubrey and Anton from Kaminsky Law, and we are talking about the legal ramifications of engaging in a way on that remodeling project that may end up biting you in the tush. So let's jump in. Let's talk from the homeowner perspective. I'm about to sign this agreement with a general contractor. What should I know before engaging in this situation?
So from a big picture perspective with as a homeowner for a general contractor, there's a couple things that you want to make sure of right away. Number one, does this general contractor have insurance? First and foremost, are they properly licensed? Now, there's free websites that you can search this information. You look up the county that you're in, the state that you're in, you search the name of the general contractor, you ask them for a certificate of insurance, you ask them for an insurance policy. If they say no, or if they get squirrely, run.
And why run? What, like, I know a lot of people, hey, they're good. They seem trustworthy. They were referred to me. They did a great job for my friend.
Yeah, the reason is, if everything goes well, you're fine, typically. However, if a contractor does some damage to your house while fixing the thing that they're fixing and they don't have insurance, you are going to be having a bad time.
Okay.
I'll just jump in and say you might not know that there's issues when they finish. It might be, a couple months from now, 6 months from now, a year from now, that you're discovering some sort of issue. And you're really going to want to make sure that your contractor has insurance to cover something like that.
Yeah. And then the second thing that I think is super important is, what does your agreement say? Do you have an agreement? How's the payment schedule being broken down?
Right.
If your contractor is asking for all this money up front and there's no real, action or no real deliverable early, that might be a problem. Are they giving you a reasonable, hey, here's the schedule. You're going to pay, 20% up front for us to get materials. Then once we do most of the work, you'll pay us the other, 30%. And then once we're almost finished, you pay 20%, and when we're done, you pay the balance. Or are they saying, give me 80% now, or I'm not coming in?
Right.
You run into a lot of issues, and we've seen people run into a lot of issues with contractors that take a lot of money up front and then don't do anything.
So yeah, and just a reminder, as we always do these episodes, is not legal advice. This is general things that you've experienced and broad-based recommendations. And you kind of gave a schedule map of like 20%, 30%, whatever. Is there a best practice? Because I feel like a lot of that is based on what the contractor asks for, what the terms of the project might be, right? If you're coming in for a one-day water heater replacement, that's going to be different than if we're doing an entire addition. So
sure.
How do you sort of differentiate between these different circumstances?
Well, I think from the homeowner's perspective, you want to see what the costs are, and you don't necessarily have to see what they're paying, because obviously they're going to make some sort of markup or profit, but you want to see how they're breaking down the number that they're charging you. So if you say, hey, I want to remodel my kitchen and my living room and install new hardwood floors, and they say $100,000, and you say, okay, well, how are you allocating that? Are you, how much is for cabinets? Do you have, a price for cabinets? How much is for the floors? How much is for your labor? A lot of times, if you get, the bigger the project, the more that tends to get lost in the weeds.
Right.
If, to your point about a hot water heater replacement, those are relatively straightforward. This is how much we're going to charge you to replace your hot water heater.
Right.
I'd still check if they have insurance, but if you agree to the number, you agree to the number. But if you're saying, hey, I want to remodel my whole house or half of my house for $100,000, you really want to see how they get to that number. And then you really want to get into a payment schedule that makes
based
sense.
On deliverables.
Right.
It's not just based on time, but it's based on deliverables. Sure. That's probably the most critical thing. So I need insurance, contractor with insurance, and I need to know a schedule of payments based on deliverables that's reasonably allocated.
Right.
Anything else we should consider?
Yeah, you want to make sure that you have some sort of agreement with them. A lot of times what people will send us when they actually get into trouble with a contractor is going to be like one sheet of paper. That sheet of paper will have an estimate on it. Sometimes if they're lucky, it'll have a payment schedule on it, and then it'll have signatures. And that's it. And there's no, hey, if this happens, we do this. How can I terminate this contract? What happens if you don't finish? Is there a fee shifting provision? And I think Aubrey will handle it from the perspective of the contractor. The contractor really wants to have an agreement. So if you're getting if you as the owner are hiring a contractor that's not really giving you an agreement, that should in and of itself be a red flag, because the contractor really should have one.
But if you've already engaged with one, and just to kind of
now you pray.
Yeah. Well, it's going to be a different video podcast. We're going to be talking about prayer and the best way to get through your remodeling project. But just, Aubrey, as we're teeing you up for this, it sounds like, Anton, you were just saying that the sort of burden of proof is on the concerns are for the contractor. Like if you have that one pager that's not very informative, your homeowner, it sounds like, is going to have a little bit of leverage if they're coming in and bringing a suit. Whereas, so it really falls on the contractor to have that agreement. Talk a little bit about that.
So the reason that as the contractor, you want that solid agreement is because there's what's called the Homeowner Improvement or Home Improvement Consumer Protection Act, or HICPA for short. And that is kind of a branch of I don't know if you've heard of like the unethical trade practices, those kinds of claims. So HICPA really protects the homeowner, and could be to the detriment of the contractor. For instance, there's actually 13 specific things that a contractor has to have in their contract for it to be valid under HICPA. And if you don't have those 13 things, and some of them are, things that you just don't think of, like there's a specific phone number that you have to have on the contract for one of the state departments. If you don't have that, then the homeowner, their first claim is going to be a violation of HICPA because it's not an enforceable contract. And so you're going to have an issue right there, right off the bat. But you really want things to protect you for if the homeowner doesn't pay.
Well, let's dive into that for a second.
Sure.
Let's go into the horror story for the contractor's perspective. So I have my one sheet, so I'm 3 of 13 checked off right in this agreement. I'm in a deficit, and we have a disagreement with the homeowner, and they come in and they bring that into court, and the courts go, this is a joke, and you are nowhere near compliant with HICMA, and what happens now? So let's use the example of the big kitchen remodel, and the homeowner is unhappy about something. Maybe they wanted different color cabinets, or they want you to install different style cabinets. Are you now responsible to replace the cabinet? What happens in that situation, or can you give us an example?
Sure. So the cabinets are a great example, because maybe the homeowner did tell you they wanted blue cabinets, and you put in green cabinets. Well, you don't have a contract that says what color the cabinets are supposed to be. And so now you have just a he said, she said dispute. And they can't, a court cannot make a contractor do anything. A court can't really make anybody do anything, any kind of like service, but they can be liable for damages if it's shown that, yes, the homeowner did say blue, and you didn't do a change order on the contract to signify that. Then you might be liable for paying the cost to replace those cabinets.
So now you're paying a different contractor that hopefully has their 13 points covered to go fix the work that maybe you didn't even do wrong. There's just a disagreement and misunderstanding because you didn't properly document as a general contractor. So that's, I think, important for the homeowners to understand that, first of all, don't sign that agreement because it's got red flags all over it. But if you do, you're in this kind of, well, let me go the other direction. If you're a homeowner that goes like, I see that this contractor, seems good, but hasn't followed these protocols, you could really take advantage of that general contractor in that situation.
Yes and no. There's a lot of, first of all, there's a lot of that. I think we'll cover that as a whole separate portion of this conversation.
Sure.
But from the homeowner's perspective, the red flag should outweigh the, I'll potentially take advantage of this, because
right.
if there's already a red flag at the contracting phase, if this company doesn't look like it has insurance, chances are by the time this job's done, this company might not even exist.
Right.
And so the person that you're going to have to go after is going to be in the wind. They're going to have no assets. It'll be messy. And so From a practical standpoint and from a psychological standpoint, from, dealing with your significant other and, if your kitchen's in disarray for a year.
Yeah, that's not disruptive at all.
Right. You really do want to make sure that some of these boxes are checked. And as much as it might pain you to say, hey, let me have a lawyer look at my contracting, right? My GC contract to remodel my house. Look, if you're spending $100,000 to remodel your house, what's a couple $1,000s to make sure that you're
doing it right?
Yeah. Hey everyone, sorry for the interruption. If you found this information helpful or useful, please take a moment to like, share, and subscribe so that we could keep producing content and so that you get notifications next time there's an episode.
All right. Thanks, Anton from Kaminsky Law, and back to the episode. And I think that, I say that tongue in cheek. I don't think that most homeowners are going like, oh, this contract's incomplete, I'm going to be able to take advantage of this general contractor. But I do think it brings up the idea that the general contractor needs to understand the liability that they're facing if they're going to have these incomplete agreements, right? And not fully fleshed out.
Yeah, and there's a lot of things from the contractor perspective that you really want to have in those agreements that really should benefit you. So, for instance, you want to have a fee shifting provision. You want to have something that says, if I have to sue you for my money, not only are you going to pay me my money, but you're going to pay me interest and my attorney's fees of getting that money from you. Again, That's a hammer that is used to, dissuade somebody from breaching the contract. And I said interest, but another thing is, if you don't pay me within 30 days of when it's due, we're going to start charging interest. Those kinds of things.
And stop work and things like that, because I imagine that could be a point of confusion. You haven't paid me for this payment milestone. I'm about to start on the next phase of the project. I'm not starting on the phase in the project until you pay me, but I have an agreement that says 3 things on it and nothing about green cabinets. And so now I am, who knows, so you really have to say, what are the terms, but also what happens if the terms are breached?
Yeah, and I think that the big picture there, and we talked about this, I think in the first time that we did a video, is it's better to have an agreement than to not have an agreement, because an agreement really, the point of a good agreement is to set forth the parties' respective rights and understandings, and a good agreement doesn't have any confusion in it. Here's what you got to do. Here's what I owe you if you do it right. Let's go proceed, and hopefully it all goes well. If you don't have that agreement, it lends itself to confusion. Oh, well, I thought you were going to do this, or I thought you were going to install green cabinets, not red cabinets, right?
Right.
And so every piece of documentation and writing is helpful, and I think more often than not, we have a lot of general contractors as clients because they're usually small businesses, and they don't want to use their own kind of, whatever, founded on the internet contract. They want to have a contract that will then be enforceable because, to your point, a homeowner will take advantage if they can. And they unfortunately, that is life, and that's, human nature to some extent. But, if you give people an inch, sometimes they take a foot. And, from a general contractor's perspective, it's definitely better to have your agreements in order before you start work for somebody.
I know we talked about the 13 areas that every contract needs to have. Are there any that are really big call outs that you want to hit that, somebody listening to this, that's a general contractor, or maybe even the homeowner, anybody that's listening would go, they should really know this one, and this one ends up with a lot of complications that jump out at you?
Well, you definitely want to have the price on there. You want to have your license on there and your insurance information on there.
So even if you're licensed and insured, but you don't have the information on the agreement, that could potentially be a breach?
Well, all just not having them on there, can be a breach.
Wow.
So it just gives the homeowner like a jump start in their lawsuit.
It gives them an out, right? And they shouldn't have an out. If you as the general contractor have done all the work,
yep,
and it's good work, and they come in and they say, well, wait, you didn't have your license number on this contract, so I'm not paying you. It's an absurd argument to make, but to your point, somebody could take advantage of it, and you want to try to avoid that.
Right, and if a judge just goes, yeah, this agreement doesn't look good to me, I don't want to deal with this, they could throw it out. Right?
It usually won't get that far,
right?
Because usually you'll get to a point where it'll either resolve or people will be at arms or odds with each other. But you don't even want to open that door, right? You don't want to have to get to that. You want to have a good, clean agreement that says, here's what our agreement is. This is a standard agreement. This is what we do. You take it or leave it kind of thing.
And to that point, from a business perspective, thinking as a general contractor that's going, I don't want to sit down with an attorney and write this agreement. Like, I love my yellow slip you get at Staples, right? I rip the top, it goes out to Susie and the whatever, and Dave gets this one, and and I've got my process. It works. I'm old school. I don't need this. The reality is that you do this once and you're set for all of these projects, correct? Or no?
Yeah, with only minor modifications for the most part. If you take on a small project and we have people that do business to business, right? So we talked about general contractor right to homeowner, but then there's also, subcontractors of the general contractor.
Right.
So sometimes those subcontractors will have a very straightforward one-page agreement, and that's typically fine if they're dealing with the same general contractor over and over again, and there's a pattern of practice. There's here's my terms. They all fit on this one sheet in size 8 font, and we're good, right? But if you're dealing with the consumer, you're dealing with the homeowner, it's not a business to business transaction, you really want to have a good agreement in place.
And let's go into that, because we were going to talk about subcontractors and that relationship too. So now we're shifting from the general contractor and the relationship with them or did you want to hit something else?
Yeah, before you go into that, I think we should talk about the rights of a contractor that doesn't get paid and the concept of the mechanics lien. And I think Aubrey, she's become our resident mechanics lien attorney, and she can speak a lot about it, and I want her to touch on this point from both mainly from the contractor perspective, but I could talk about some defenses to it from the owner's
as a
perspective.
lay person. You're going from general contracting to automotive. What's this mechanics lien thing?
So the mechanics lien is you can get it on automobiles, but you can also get it on homes, and it's for when someone's provided services to you and you haven't paid. And so you can get what's basically called a lien on their property. And it's set, and the way it works is this lien attaches to the property. It says you owe, that the person that owns the house owes me X amount of dollars. And that lien stays with the prothonotary. It's searchable if someone's pulling the title or the deed. And if that person is going to go sell their house anytime soon, especially if it's a new build and it's a development company and they own this property, they need to sell these houses. Well, if they're not paying their contractor and the contractor puts a lien, when they go to close, that lien has to be satisfied, or they're not going to be able to transfer the title to the homeowner.
And at that point, if you've gotten that lien on there, right, if there was an opportunity for negotiation or anything like that, that's gone, because once the sale happens, the money's just forwarded on to the contractor, right, to the damaged parties.
Yes and no.
Yeah.
I think that,
I'm getting a sense that in the legal space, everything is yes and no.
It depends.
That's right. So the concept of a mechanics lien, and this is important to set up for the audience, the concept of a mechanics lien is that most cases, if I'm suing you for something, before there's a lien or a judgment that says you owe me money, we have to go through the whole entire process, right? Okay. We have to get in front of a judge or a jury, and the jury has to find that you owe me money. The mechanics lien process shortcuts that process. It basically says you've given me enough information to establish that this person probably owes you money. We're going to put a lien on their property, and then you guys can resolve whether or not they actually owe you that money.
Okay.
And so when you ask the question of whether or not,
right,
that's it, it's over,
yeah.
It's not necessarily over, but what it does is it adds pressure to whoever's owning the house, because if they want to sell it or refinance it, right, the bank won't let you refinance it until the liens are paid off either. So if they want to sell it or refinance it, what they have to do is they have to deal with all the people that have a lien on the property.
So it prohibits you completely for, you can't make the transaction, or do you make the transaction and then the money gets pulled aside and lives somewhere until it gets resolved?
It's the second. It's basically that money needs to be paid out of the closing price or of the refinance, right? So if you have a simple example, if you have a $500,000 house, somebody's got a lien on it for $100,000, you sell it for $500,000, you're really only getting $400,000. That person should get their $100,000, or it gets deposited into the court. Yeah.
Got it. Okay.
And where Aubrey was going with this is it incentivizes having the conversation now.
Got it.
Right. But there's very strict standards around whether or not you can get a mechanics lien. And I'm going to,
Yeah. And what are those? What are those strict standards?
So first of all, there's a timeline on it. And so it goes from the day that you substantially complete the work. So if you're a contractor, you built the house is, 99% there, and there's a punch list, and maybe you go back, a month or two after the house is complete, and you complete that punch list. The day that you start counting is the day that you substantially completed the house, not the last time you were there to make a repair or fix something. And the timeline is 6 months to file a lien. If you do not file the lien within that time, it can get stricken. And
so you don't have to wait 6 months to file it. You have to file it within the 6 months from that time.
As soon as you finish the project, it could be building a whole house. It could be remodeling, a portion of the house. As soon as you finish the project, if you haven't been paid, that is when the time starts ticking.
Got it. And does the term, just thinking back to the 13 points, I'm thinking of like the 10 commandments, but like the 13 points for the proper contractual GC. In that environment, you have to have those things in place in order to be in a position to get the mechanics lien. Is
not necessarily.
Okay, so you could still, if you made the mistake of not having a proper contract, you might still be okay.
Yes. So if you can show that they owe you this money, either through emails or through payments, if you're sending them an invoice and they're paying on the invoice, maybe it's not an actual contract, but it's still showing a balance. And so you have some sort of proof of what you're owed. And so you use that to establish your lien. Because the lien goes before, as Anton was saying, before you actually can get a judgment, and it puts the cart before the horse, everything that's in that statute must be strictly followed. If you vary off of any of the requirements, your lien can get stricken.
Okay. So we just say this a lot when we have these episodes, hire an attorney, right? But so you got to get an attorney in. Is there a time frame? So for example, I've got this 6 month clock that I got to get this lien in. I get my documents to an attorney. Does it take the attorney, even if you could turn it around in 24 hours, the processing of it, is there a certain amount of time that I need to, you know what I mean? Like if I start at 5 months and 10 days, am I probably not going to make that 6 month time frame? Like what should I consider in terms of my real lead time?
If you're a general contractor, I would say you want to contact us within 2 to 3 months of not being paid. Ideally, contact us sooner than that, but within 2 to 3 months, we can probably get it in. If you are a subcontractor, you are also required to send a notice of intent to lien to the homeowner. And you have to do that and give the homeowner 30 days to respond, because generally, the homeowner might not know that the subcontractor is owed money, because a lot of times the GC is handling all that. So you have to give the homeowner notice of what's owed. And there's very specific things that have to be in the notice as well. And so you need to, you need the property address, you need the amount owed, things like that. And once you send that notice, after the 30 days, you can file the mechanics lien. Once you file the mechanics lien, it has to be served. It has to be served. There's very specific people that can serve it. Sometimes in limited instances, you can have, the processor, or like you see in the movies, goes out, you've been served. Yep. Other times it has to be the sheriff. And if you don't do that correctly, your lien can be struck. Once you serve the lien, you have a very limited amount of time to get the affidavit of service on the record. And if you don't serve it within the certain amount of time, or you don't get it back onto the, filed within the certain amount of time, again, it can be struck.
Wow. So that is a lot of requirements just to get paid when you're due, or to get, not even get paid, just to get the lien on and maintain the lien. Yeah. Is there?
I was going to add the one thing. So you asked the question, if you show up at 5 months and 10 days, can we help? If you're a general contractor, maybe, right? We could file the lien and ask questions later. But if you're the subcontractor, no, we can't, because that doesn't allot for our 30 days to provide notice to the homeowner and then file it, right? So if you're a subcontractor, which means you didn't contract directly with the owner of the house and you contracted with a general contractor and you haven't been paid, you have to be even more vigilant and you have to protect your rights even more so.
Wow. So that really is surprising to me because, and I just want to understand the relationship because this is a big surprise. So to me, my understanding is if you're the general contractor, you have the relationship with the client, and everybody you hire under you as a subcontractor, their relationships with you, period, end of story. But what you're saying is that in the case of the homeowner refusing to pay for whatever reason, the full amount owed to the general contractor reserves the right, presumably because they have a proper agreement with the subcontractor, to turn around and go, hey, I haven't collected my money, so I'm not paying you. And now that subcontractor has to turn around and go, I'm going directly to this, to the customer, to the homeowner. And you never probably contracted with them at all, other than maybe getting a text or an email as to where their address is. So now you've got to collect all that information, presumably from the GC, hoping that they're willing to share that with you in a timely manner. Collect all that information, get everything set up, find an attorney, so you really, if you're a subcontractor, what I'm hearing from you guys, and again, call a lawyer, don't wait too long. But if you're a general contractor, that 6 months seems to erode very quickly. So if you're not paid within the first 30 days, you probably should be thinking about, how do I get this lien? And if you're a subcontractor, even sooner, it sounds like. I mean, this is like immediate almost.
Yeah, I would say 6 months is more than enough time. I would say that for a general contractor, Aubrey said, 2-3 months in. Look, most people's payment terms are 30 days, right? So you don't really even know you're not paid for at least 30 days.
So now you're off by a month, but you're down to 5 months.
Yeah, but I think that if you're a subcontractor and it's been 90 days and you haven't been paid, you really got to get on it, because we need a month to send a letter, right? So if you come to us and you're kind of sitting on your rights and kind of just saying I'll deal with it later, you might miss your window altogether.
So it's shocking to me because I feel like there's a subcontractor, and Aubrey, maybe you can speak to this. Like, as a subcontractor, I would kind of expect that my contract is with the general contractor. I don't care which house I'm going to and who the homeowner is. I'm the window person, right? So I come in, I did my windows, GC, pay me. Oh, you didn't get paid? That's not my problem. Does that come back to an agreement that I should have had with my GC?
Correct. So, and I would say that your issue with the contractor not paying you is its own kind of separate lawsuit. So even if you get the mechanics lien, you can still bring a regular lawsuit. Even if you lost the right to bring the mechanics lien, you still have, breach of contract, breach of implied contract, unjust enrichment, these kinds of things you can still bring even if you're not able to get that lien. For a subcontractor, you really want to have an attorney look at your agreement, because there are things in there that waive your right to lien. And I've seen it in subcontractor agreements where they agree that they won't seek a lien on the property. I've seen terms where the contractor has agreed with the homeowner not to seek any type of lien, and they can do that on behalf of themselves and the subcontractors.
Wow.
And
so do you need to ask to see the GC agreement too?
I would ask the GC if they've signed any waiver of lien or anything to do with filing a lien on the property if they've waived their right.
Let's hit that really quick.
Yeah.
So give me the list of things. If I'm a subcontractor, I love these rapid fire questions. Give me, what's my short list if I'm a subcontractor, right? I should have more than a one pager type 8 font, I believe was the font that you used on Courier New with my GC. But what's my short list of things that I should really do when I'm signing with the GC and when I'm working on a project as a sub? And then we'll go by GC and homeowner.
So it's interesting, and it's a good question. So as a sub, a lot of times you get kind of, here's the GC contract. Do you want to take it or leave it? Mm-hmm. Right? So the general contractor, if they're big enough and if this is a big enough project, they're doing what's called putting out bids, right? And so they say, okay, we need windows. We're going to go to 4 or 5 subs that do windows and say, how much are you going to charge? And then they say whatever number they say, and then they say, here's my contract. Sign it. Maybe you don't want to do that. Maybe you want to read that contract. So I think that's one of the biggest points for the subcontractor. And to Aubrey's point, I mean, there's this concept called release of lien. And typically that is used when the sub has been paid in full for their work. They will then sign a document that says, okay, I've been paid in full. I'm agreeing that I won't file a mechanics lien on this property. Okay. That's the reasonable and normal way to use it. However, that gets abused. People say, sign this contract and sign this release of lien, before you've performed any work on this thing, or, before you've been paid a penny. And so subcontractors a lot of times don't know these things, and they're usually, again, smaller mom and pop, small business.
Sure.
And if they push back on this, a lot of times general contractor will say, okay, fine. Sometimes general contractor will say, okay, I'm going to deal with somebody else then that's going to sign my agreement. But there's risks to that too. I mean, and we'll talk about the insurance and the liability risks, I think, a little bit down the line.
And the courts don't inherently protect you. I mean, if in the same way that we've talked in the past about non-competes and things like that, the courts don't have a provision where if you sign this release before you even started the work, where the courts go, hey, this was unreasonable. Well, it just you signed it, and that's it.
I think that there's a misconception about how courts work for people. I think that, and I think you're a perfect example of it right now. By the time that we have a court or a judge review whether or not that piece of paper is valid, each of us will have spent tens of thousands of dollars.
Right.
And so I think a lot of the way that lawyers and court systems work is it's really, an exercise of holding bigger and bigger guns to each other's heads. And so if you have...
It's a great visual. I hope we can find a
right.
way to
It's like
that.
What is it? The Marvin the Martian with his big gun.
Right.
Anyway, so if you have this release of lien that you signed for no consideration whatsoever...
Mm-hmm.
Maybe that is an invalid document, right? But by the time that you actually have a judge decide that, you will have spent so much money. And so it doesn't matter whether it's a valid or a non-valid document. I mean, it matters for legal purposes and for taking the thing all the way down the line, but for practical purposes, it doesn't matter.
Right. And if you did a $20,000, $30,000, even $50,000 window job as the subcontractor, and now you're waiting 6 months to a year and dealing with the courts on the side and spending tens of thousands of dollars on top, is that really money well spent?
Right. And that's why to answer your question, that's why this mechanics lien statute exists. And because it is that protection. Right. Mm-hmm. So now I'm the subcontractor. I'm getting the short end of all of the sticks. I'm filing a lien. So the only thing that can prevent me, and I don't want to say the only thing, one of the main things that can prevent me is signing this release of liens. So, if you're a subcontractor listening to this, don't just sign documents. Okay. Make sure you're getting paid before you sign documents, or make sure that you read your agreement or have a lawyer read your agreement before you sign documents.
In the contracting world, what do we say? Measure twice, cut once, right? So this would be the equivalent of that, I guess.
Yeah. We're the second measure.
You're the second measure. I love it. And I think that as I'm hearing this more, well, I want to ask one more question to that point, because we've been talking about this in the good faith example where the homeowner's not paying and the general contractor and the subcontractor are in a bad way. But what happens when you have a homeowner that it sounds like if the homeowner's paying, the GC isn't, the GC is just not passing on those funds to the subcontractor, their recourse is to go hit the homeowner. But that doesn't really solve, is that the case? Like, am I misunderstanding how this works?
So I actually just did one of these cases, and it was an interesting one. So the mechanics lien statute protects against that too, and they've considered it. They thought about your question and they've answered it right there.
Damn, I was hoping
in 1969.
I was going to be like the Goodwill Hunting of the law, and they were going to be like, this guy just walked in and solved the equation in one podcast.
Yeah. So there's an explicit protection there. So the rule is a subcontractor can't file a mechanics lien if the owner has paid the full contract price to the general contractor. And it was for a single family home. Or it doesn't have to be a single family home, but it's a home that's not intended to be like a multifamily. Okay. So it could be like a townhouse or a condo, but it just can't be like a big condo building.
Got it.
And so if it's intended as a single family residence and the owner has paid in full to the general contractor and they can show that, then the subcontractor can't file a lien against the owner.
Got it. And they just have to deal directly with the GC.
Right. That's really their only recourse. And if they do file that, then the owner can go in and get it stricken on that basis by coming and showing, here's the contract, here's me paying it, leave me alone.
Okay. Got it. And so in that environment, your subcontractor is just fighting directly with the GC. I guess in the environment where it becomes a little messier is you're in that punch list zone, right? Homeowners going, this isn't done right. I'm withholding funds until things are fixed, whatever that is. GC's going, it was done right, or this isn't part of scope. There's that fight happening. Oh, by the way, I haven't collected my money. sorry, window people. I don't know whether we were picking on the window people today, but there are our go-to example subcontractor. Sorry, subcontractor, I can't pay you until I get paid. And now we're in the stalemate. And that's where it's like, I could maybe compel the homeowner with a little bit of a lien. And is that a cleaner example or a messier example?
It winds up being a good pressure point for sure. I think that the thing that it all boils down to is what is the agreement between the subcontractor and the GC say? Because maybe the GC is saying, okay, I'm withholding payment because I haven't been paid, but they got paid 95%, but they've paid me 0%.
Right.
And so, again, what does the agreement say? And that's another reason why you want to go to a lawyer and have them look at your agreement.
All right, let's hit some rapid fire takeaways, right? So I want to start with our homeowner. This should be pretty easy. What are 3, maybe 5 things I need to do and consider when I'm hiring a general contractor? Top 5, top 3, whatever you think of.
Make sure they're licensed. Make sure they have insurance. Make sure that you are getting some sort of contract. Ask them for something more than just an estimate so that you can protect your rights.
And
I would add
won
to
13
that,
points.
I would add to that to make sure that the timing of your payment is something reasonable.
Okay.
That you're not paying up front and then later having to chase somebody down that's not doing any work.
As a homeowner, because I now know that down here in the subcontractor land, they can swing around and put a lien on my property. Should I be asking anything about your relationship with your subcontractors? Where is that specified? Is my agreement with my GC something that I want to know how they're handling things with their subs to protect myself on the back end in case something does go awry, that I'm not getting a lien from 3 different directions?
Yeah, as you have the bigger projects, you definitely want to be thinking about those things. You definitely should see the agreement with the GC. And, is it a big lift to ask to see the agreement that they enter into the subcontractors? Maybe, right?
Okay.
It's a lot because you're a homeowner. You don't understand this stuff usually. You're saying remodel my house, and the fact that they're bringing in a different wood guy and a different window guy shouldn't bother you. It should all fall on the GC, but that then goes on how important it is that you don't just have some Joe Schmo being your GC, having it be a real company that's, licensed. That's, in some cases, if the projects are big enough, you want them to be bonded, which means that there's, they put up money in case they screw up.
Yep.
That you have a pot that you can go after. And it's, that's really your bigger remedy. The scary thing for a homeowner is if you enter into a project with a shoddy Joe Schmo GC and then, you get bad subcontract work and then you go after the GC and the GC's just like, sorry, I got nothing, right? Or I don't exist, or my company wound down, or I'm bankrupt and good luck collecting because I moved to Mississippi or whatever. And, you're pretty much stuck now. And it's, they're kind of your weakest link, and now you're kind of screwed. And I think that that might be a good segue into the insurance piece of it.
Yeah, for sure. So when you are a contractor or a subcontractor, you need to have insurance. Probably goes without saying. But you want to make sure that your insurance covers what you're doing. So you definitely want to talk to your broker, talk to your insurance agent, and tell them, exactly what kind of work you're doing. Are you doing new build? Are you doing renovations? Are you, those types of things? Are you working on commercial? Are you working on residential? There are exclusions in there because, a contract is so many pages, but an insurance policy is,
all of the
50,
pages.
100. Yes, exactly.
There's all the rest of the pages.
Yes. And so you really want to be very clear with what you're doing so that you can get the appropriate insurance. And because things I've seen is contractors doing new homes, building new homes, and their insurance policy includes a new home exclusion or new build exclusion. So if the homeowner comes back and there's issues with the workmanship, it's not covered under your insurance. There's also there's an occurrence policy, and so anything that happens, you make a claim against it, and it's typically faulty workmanship is is the big claim that is mostly made in these kinds of contracts. And most insurance companies argue that that's not an occurrence. An occurrence is, an accident that affects other parts of the property. And so to get the insurance to cover it, there really needs to be something that you can point to that says the faulty workmanship damaged another part of the house that the contractor didn't work on. And
whoa. Okay. So that is a huge
big distinction.
Yeah.
Yes.
It's a big distinction. And the easy way to think about it is this, right? If I come in and I redo your bathroom, okay? And I redo your bathroom and I do a horrible job. The tiles are all messed up. The sink is horrible. It's off-centered, whatever it is. And you and then you sue me for how horrible I did the bathroom. My insurance policy is not going to cover bad work. It's just not.
Okay.
So that's just a direct claim. Your insurance can't protect against that. But
when you say your insurance, the general contractor's insurance won't protect
the contractor's
them.
Insurance won't protect that. And
Okay.
so they don't protect crappy work. But if the way that I installed your toilet, caused the pipe to burst and flood your kitchen,
Now you
the
have a claim.
kitchen would be covered.
But not the it's
But
kind of
not
like
the
when you-
repair of the bathroom.
Right. It's kind of like if you have an incident where, there's a leak in your roof that's caused by a storm, you might have coverage for the damage from it, but not the repair of the
roof.
the leak, of the
Right,
roof or
yeah,
whatever.
right.
Right. So, okay. So that's good to know. As a homeowner though, am I supposed to, I know I keep coming to protecting the homeowner. But as a homeowner, is it enough to just know that they have insurance? Because if you're like, yes, I have insurance, but there was an exclusion on new home construction. I happen to be building a new home. Is there a vetting process for that? Or how do you think about that if you're a homeowner? Or are you rolling the dice even in those situations?
I think that's a really good question. I think what you can ask for is the certificate of insurance, and it's like a one-pager. It has their insurance policy number, the company, things like that, and what their policy limits are. And you can always call the insurance company and verify that insurance is active. More than that, I don't know how much deeper you really can go without asking the contractor to see their policy and looking at it yourself. You could ask him, general questions about that, but it is somewhat rolling the dice. But if you can verify that the insurance is active, that's really the best way I think you can protect yourself.
Yeah.
You can also go to usually these certificates of insurance will have a broker, and more often than not, it's an insurance broker. So you could also reach out to the broker and say, hey, this person's about to perform work on my house. They gave me this COI. Can you confirm what the coverages are and aren't? And I think that's an interesting segue into, you're thinking about the homeowner, which is great. We think a lot of the times about the small business that calls us.
Right.
And so from the small business's perspective, it's also very interesting because the GC, right? Let's say we represent the GC, and very often their insurance policy is not covering the things that it needs to cover for the work that they're doing, which is what Aubrey just touched on. And you're like, how do you protect that? And so you should really be having conversations with the brokers in writing, preferably, because then you could potentially go after their insurance if they screw up.
Right.
Saying, this is what I do. This is what I need coverage for. Because later, if it turns out that you don't have coverage, now they're suing you directly. And for a lot of claims, those get really expensive. Let's say you helped build a new house, and it's $1 million house,
right?
And some tiny window that you installed is leaking. Well, they're suing you for $1 million. Their whole house sucks because your window sucks, right?
Right.
And now you look at your policy, 2 years later that you get this claim, not, a week when you got the policy, and it says, we are excluding new house construction. And you're like, I had no idea. Well, guess who's getting sued? You are now.
Yeah.
And usually, one of the other factors for piercing the corporate veil is you don't maintain adequate insurance. And so you fail to maintain adequate insurance as your business, and now guess what? You're getting sued personally because your broker screwed up. And so I think that's a huge, point.
So this is rapid fire for a general contractor thinking about the things they need to do in terms of their insurance.
Right. Number one is make sure that your policy covers the things you do. Whether you're talking to a broker or you're dealing with the insurance company directly, you should have a written email, a list somewhere that says, this is what we do, this is what we might do, this is the types of homes we work on, make sure my policy covers it. And sometimes what you'll do is you'll get an offer for a way cheaper policy, and you have to ask the question, does this policy still cover the things that I do? There's multifamily exclusions, right? Maybe you build single family houses, but if you build an apartment building, you don't have insurance for that.
So it's not just have the paper. So it's ask the question. It's have a paper trail that shows you asked the question. And then it's when you're comparing policies, have a paper trail showing that you double checked that they still were covering you properly for the paper trail for the policy that you double checked earlier. That it's a lot of a burden to make sure you have the right insurance.
Yeah, and maybe you should call a lawyer that can help you walk through that process.
Sure.
And we've seen these claims. We've seen these claims when there's no insurance coverage. I mean, we could do a whole separate podcast about what we do if there's no insurance coverage, even though you thought there was going to be insurance coverage.
It's brutal because if you think about a lot of these contractors, they start out probably as a smaller outfit, maybe even a single person that's doing, handiwork, and then they grow a business. And what they started doing and what they are doing are two different things now. And the insurance is still lingering over that they're paying from back who they were, not who they are now.
And they're thinking about paying for the cheapest policy, right? A lot of times you're like, oh, this insurance is so expensive. Give me the cheapest policy. Well, make sure that those exclusions are not excluding your business.
Right. Watch out for the exclusions. Yeah. That is a great note.
There's a second thing.
Yeah.
Let's do a rapid fire volume 2. When you are a general contractor hiring subcontractors, this is an ultimate minefield, okay? You should make sure that your subcontractor's insurance covers the things that they're doing.
Got it.
Because your general contractor's insurance may very often exclude the things that should be covered by that subcontractor. Do you understand?
Okay, got it. So yeah,
I'm a GC.
Yep.
I'm a GC. I'm looking for the cheapest policy I could have. I'm going to shift all of my liability to my subcontractors.
Did they actually take it?
Does their insurance policy cover it? Because if I shifted that liability, but their insurance policy doesn't cover it, again, you get into the thing of I hired Joe Schmo window guy. Sorry, window guy. And Joe Schmo window guy doesn't have insurance. He screwed up the windows. There's a lawsuit. They name everybody. They name the general contractor and the window guy.
Right.
And the window guy doesn't have insurance. So guess who's picking it up?
So, Aubrey, you talked about this earlier. It sounds like it's a difficult thing to do, but maybe, Anton, in what you're describing, it's easier when it's not the homeowner. But should you be asking to review your subcontractor's policy? Do you need to bring in an attorney at that point and maybe a broker and have a dialogue there? What does that process look like in an ideal world? Because I think you guys, unfortunately, end up being reactionary a lot, right? People are coming to you when there's already something's broken. If you had your magic wand to get people to do things the proper way, what would sort of that protocol be to make sure that they didn't get into this situation to begin with?
Sure. You would definitely want to ask for the COI, the certificate of insurance, and you should call, the contractor should definitely be calling and making sure that the subcontractor is covered, that the work that they're doing is covered. Make sure that the, broker knows what kind of construction it is, things like that, and knowing what the exclusions are, because that can come out in a deposition. Did you actually call the insurance and make sure it was valid? When you're trying to shift the blame to the subcontractor, and that's what happens. The homeowner sues the contractor. The contractor then turns around and sues all of the subcontractors. And then everybody is like, it is not my fault, it's your fault. And so in a deposition, things like that, the subcontractor is trying to shift it back to the GC. So if the GC isn't ensuring that you're maintaining proper insurance,
that's on them.
Right.
The other thing that you should think about is when you're you keep putting yourself in the homeowner's shoes. And I think that's a great take here. When you are in the owner's shoes and you're hiring a general contractor, the expectation that you have is that general contractor is using subcontractors that they've vetted, that they've worked with a lot, that they know are going to do a good job.
For sure.
And so, that burden is on the general contractor. That's why the general contractor is getting paid. And so part of their job really does need to be to make sure that their Rolodex of subcontractors that do windows are all people that do a good job, that are properly insured, and that have like a viable company. And if the general contractor brings in Joe Schmo, the window guy, it really does fall on the general contractor.
Right. And that's how the law sees it.
That's how the law sees it, and that's really practical, right? Because I, as the homeowner, have no idea who your subcontractors are. I didn't contract with them, I didn't vet with them, and I don't work with them on a regular basis.
Speaking of that, side note that I do think affects everybody in this situation. These projects sometimes have multi-month, multi-year time horizons, right? If you're building a whole house, you might be doing that for months. If you're building a community, more. You're renovating a kitchen, right? I checked at the beginning when I signed the agreement. You had insurance. I even called your broker, and it's great insurance. 3 weeks go by, and the insurance lapses, right? Is there any protection? Like, am I checking every week? Is this my new plan while my kitchen's being remodeled? If I'm a general contractor, am I checking the sub every time? Every morning I wake up and I go in and I go, hey, do you still have your insurance? How do we... is there a best practice? Is there a leap of faith? Is there something that the law protects people against? What's the best practice? What should people know?
It's in the agreements. Typically, it'll be in the agreement, in the insurance provision. It'll say that you shall maintain this insurance for the duration of this agreement. And if for whatever reason you're going to change insurance or your insurance lapses, you have to give me 30 days notice. And if your insurance lapses and you give me 30 days notice, I have the right to continue to pay for your insurance, and then you have to reimburse me. That's what those agreements typically say. Now, in practice, to answer your question, usually doesn't happen. But I think that goes back to falling on the GC, because it really does need to be the GC's responsibility and liability when it comes to making sure that the subcontractors are properly insured.
And so when people are listening to this video, and watching this video, I think that as a general contractor, you're listening to this, you should understand that the liability and all these responsibilities are really fun. And that's why you're the general contractor. You're putting all these pieces together. And so you should get your ducks in a row. If you're a homeowner, right, the GCs who you should be looking to. And that's why all of those quick hits that we discussed, the contract, the license and insured, those types of things are so important, because they're one step closer to the truth of this contractor being the right fit or the not right fit. And same thing on the subcontractor side. Like, if your general contractor doesn't seem to be following best practices, isn't concerned with your insurance, isn't concerned with theirs, they're probably not going to be a great long-term partner. And these are things that you should protect yourself against.
And you know what else you can do? I just thought of it. So when you get a COI, it'll tell you how long the time period is that they're insured, right? So it'll say, from February 24 to February 25.
Right.
So maybe set an alarm on your phone. Hey, in February 25, let me just double check that this person has insurance still. Right. And again, this only goes to the person you're dealing with and for extremely long-term contract. But, as a homeowner, to protect yourself, that's what you want to do.
Sure.
And I think as a homeowner, again, it's great that you're asking these questions from a homeowner's perspective, but you guys, if anybody's that stayed tuned for this whole video, you could see how complicated and how many moving parts there are in this thing.
Right.
And if you're doing a $2,000 or a $5,000 quick fix, you shouldn't get bogged down with this stuff. You really shouldn't. But if you're going to do a $100,000, $200,000 remodel to your house, you really want to get your ducks in a row, and maybe spending some time and money on a lawyer is the right thing to make sure that this situation is not one that completely gets away from you. Because unfortunately, we see these things when the situation has gotten out of hand. The contractor's been overpaid by tens of thousands of dollars, and recovering that money is just unlikely. Right. It's very difficult. And, now you're finding out that they don't have the right insurances in place. And now you're finding out that, Joe Schmo, the window guy, doesn't exist. And now you're finding out that Joe Schmo, the window guy, doesn't even have insurance to begin with.
Right.
And so, the bigger the project, the more it makes sense to call a lawyer early.
And then I think let's go, but your focus and you support and work a lot with the general contractors and the subcontractors that are also in this sort of mess of a situation. So let's think about that for a second. And what are the last kind of tips that you would say to them when to bring in an attorney at the different phases? So maybe, we've done the quick hits on here, some tips in these specific areas, but let's talk holistically. This is a business owner. Phase one is your initial document checking, I imagine. Phase two is your milestone payment things, and then your ongoing process, change order process. Like, talk about some things that you think a lawyer should be involved with, validating, and which vendors, insurance folks, things like that need to come in as well.
I think when you're starting, definitely having your contract reviewed with the subcontract, or if you're a sub with the GC, or if you're the GC with the sub, you're having that contract reviewed. And then towards if there ever is insurance, an insurance claim and it's denied, call us, because we also will review the denial letter, we'll review your policy, and we'll make arguments as to why it should be covered. And I've gotten several GCs and subs covered when they were denied at first. And so that's another area where we can come in and we can really help when you're at that stage where you're looking at a lot of money coming out of your pocket.
That's a phenomenal thing to bring up, because we've talked about all your potential risk with the insurance that you've selected. But there's also, if there's going to be that discrepancy in terms of what I said to my broker, what they heard, what they ended up giving me, if you, especially helps if you have your ducks in a row and you actually have documentation of what you supplied them with, an attorney can come in and help you if you're in the really tough situation of, hey, there's a claim and you're being denied and you shouldn't be. Aubrey, are there any other things that you should be looking out for when you're vetting these insurance agreements?
Sure. So if you are a contractor or subcontractor, and you're looking at your policy, you want what's called a Kavner endorsement, and you should ask your broker about that. It is an endorsement to your policy that takes the meaning of accident and changes it. So it includes, without getting too technical, it essentially includes the faulty workmanship. So now your remodeled bathroom that's flooded your kitchen's covered and the flooding is covered.
Got it. So there is a way to, now if it's a situation where the tile's ugly and this isn't great and it's just not installed well, does that apply in those situations as well? Or is it more if there's a claim from the perspective of damage?
I would say, without getting too much into detail, it's more of the damage. If the homeowner doesn't like the tile or it's the wrong color, that's going to be different. But if the tile is installed incorrectly, and that can be something that can be covered under the endorsement. And
so who gets it? Is the general contractor the one that gets to bring that in and go, hey, there's damages against me because the subcontractor didn't put the tile in correctly and now it's not functional. I need to get this endorsement, I need to get funds from this to pay a different subcontractor to go fix it. Is it the homeowner who's benefiting in that case, or how is it being utilized?
Well, the person that has the insurance is really, I guess the homeowner, anybody that's getting money for their damages is benefiting, but really it's the mom and pop business. You have this Kavner endorsement. If you didn't have that and, let's say the remodel of the bathroom was bad and it didn't affect anything else. So now you just have faulty workmanship and that's $20,000 to fix. Now that's coming out of your pocket because your insurance is not going to cover it because you don't have that endorsement. Whereas if you do have that endorsement, that $20,000, the insurance is going to pay and you don't have to worry about that.
Yeah, and one of the things that Aubrey's done really well in the last few years, I would say, is a lot of times the insurance policy the insurance company has to defend the lawsuit. They might not cover the claim, but they have to defend the lawsuit. And those are two different things. But as part of first of all, they'll try to not defend the lawsuit, right? And so you'll spend a little bit of money with us, but we'll try to get you a defense, which then will shift the whole big weight of defending the lawsuit to the insurance company. That's first and foremost, and I think we've saved people a lot of money that way. The second thing is, once they're already defending the lawsuit, there's this cost of defense question, right? So, and that cost of defense question is, how much is it going to cost the insurance company to take it from here all the way to the end zone where there's a jury or a judge making a decision? And so if that number is big enough, the insurance company will very often be willing to put that money up towards settling the case, even though they don't actually have to cover your claim. But they're willing to settle the case just so they don't have to pay to defend it this whole time. And so those are levers and pressure points that we can push on because we've had experience doing it, and that really goes in your favor. And similarly, if you have emails with your broker saying this is the coverage that I want or I need, and the broker doesn't get you that coverage, we can get the broker roped in and say, hey guys, you better kick into this settlement or else you're getting sued next. And so, as lawyers, we have a lot of levers that we can help you push or pull. in these kinds of complex situations where there's so many moving parts, there's so many parties,
Right.
and it's almost like a dance, and a lot of people just aren't versed to that dance, and a lot of people that are getting sued for the first time, they kind of freeze up like deer in headlights, and they're like, what do I do? And they just start dumping money at it, and you really want to go to somebody that has experience doing it and can help guide you as they go.
That makes a lot of sense. And I think as we wrap up here, the big takeaways, without going back through all of the rapid fires and everything that we talked about, is number one, if you're a general contractor, subcontractor, homeowner, and you're in the situation where you're going to do a remodel, new home, whatever, do your due diligence, right? But as happens in this world, if there's something that got missed, there's still a ton of value that an attorney is going to bring. If your if your GC and your insurance says that they're not going to make good on the claim, there may be recourse. If there's an issue with the GC not paying you as a subcontractor, you might be able to get that mechanics leak. And I think that those are the things that I hear are the really big takeaways is do your due diligence, bring in an attorney at each of those phases when you can to make sure you are. And if you haven't, you still have the support of smart folks like you guys at Kaminsky that can help you get through it.
Thank you.
Thank you.